Good afternoon, Chairman Steele, members of the committee. My name is Daniel Abrahamson. I'm Director of Legal Affairs for the Drug Policy Alliance. And the Drug Policy Alliance is the nation's leading organization working to promote alternatives to punitive drug laws. We advocate for new drug policies that are grounded in science, compassion, health, and human rights. I hail from Wisconsin, but Indiana holds special importance to my family. Both of my parents are proud graduates of Indiana University, and my mother is a proud member of the Indiana Bar. So I'm honored to be here this afternoon in a state that means so much to my family. I have some background in marijuana law reform through my involvement in litigation, legislative drafting, and public education and advocacy involving medical marijuana, marijuana decriminalization, and legalization initiatives across the country. There are many options for state-level marijuana policy that diverge from the federal policy of prohibition, and that states are free to embrace a more rational, humane, and cost-saving approach to dealing with marijuana use. I'm going to focus my remarks this afternoon on a couple points, and I'm happy to answer any questions that you may have. My first point is that although marijuana is illegal under federal law, states remain free to legislate however they like with respect to marijuana under state law. The federal government cannot require states to make marijuana illegal. Secondly, many states, as Senator Talian has pointed out, have departed radically from federal law by exploring different approaches to marijuana policy. And they've done so in order to reduce rates of incarceration, preserve precious correctional and law enforcement resources, help patients obtain medicine that works for them, and raise tens of millions of dollars in tax revenue. And third, I'm going to discuss some important lessons that we can learn and have learned from state-level marijuana law reforms that have been undertaken in recent years. Those lessons include the following. First, states that have enacted medical marijuana laws or that have decriminalized minor marijuana offenses have not experienced increases in crime, increases in drug use, increased access to drugs, including marijuana, by adolescents, or other negative consequences. Second, as a matter of law, the federal government cannot and has not blocked or undone state attempts to substantially lessen or entirely eliminate state penalties for the possession, use, cultivation, transportation, and exchange of marijuana. And finally, with respect to state and local efforts to affirmatively regulate marijuana cultivation, licensing, taxation, and the like, as a matter of practice, the federal government has not interfered with responsible regulatory schemes promulgated and enforced by the states. Now, my written testimony that's being circulated has many sources and citations to it. I'm not obviously going to use those in my oral testimony, but I refer you to the written testimony for the sources for many of the propositions that I'll be speaking about this afternoon. Again, my first point is simply Indiana is free to change state law. Indiana, as a sovereign state, is free to explore different marijuana policies than the one currently in place in Indiana or the one set out by federal law. There is nothing, absolutely nothing in the United States Constitution that requires Indiana to criminalize anything under its state law. If Indiana decides to lessen state penalties for marijuana-related offenses, or to abolish certain marijuana offenses altogether, or to legalize marijuana just for medical purposes, it is free to do so today. Mr. Mamber, who's going to be speaking after me, is going to go into a little bit of the history of marijuana prohibition or lack thereof in the United States. But the general notion that I want to bring to your attention right now is that for many years, states have departed from federal policy with respect to marijuana, and they've done so under the principle of what our Supreme Court has termed our federalism. One of the goals of our federalist structure in this country is to foster innovation by allowing the states to serve as laboratories for the experimentation of public policy. Dispersing power to the states encourages the evolution of ideas that can help advance issues nationally. This experimentation is exactly what's happening right now in marijuana policy among the various states. The states are serving as laboratories of experiments, and it is perfect time for Indiana to study those policies and see what works best. Now, Senator Talion described in her PowerPoint presentation a number of states that over the past decades have reduced criminal penalties for minor marijuana offenses and have enacted medical marijuana laws and programs, and so I'm not going to cover the same ground that she covered in her presentation. But let me summarize this. With respect to decriminalization, at least 14 states, including Minnesota, Nebraska, Ohio, and Mississippi, have already enacted various forms of marijuana decriminalization, reducing or eliminating penalties for minor marijuana offenders. And as Senator Talion notes, Alaska, a particularly conservative state, not only permits 1 ounce or less of possession of marijuana in the privacy of one's home, it also allows, in the privacy of one's home, people to cultivate up to 24 marijuana plants. Again, my written testimony provides more details about each of these states' schemes. In addition to what has already been done, several states are currently considering marijuana decriminalization. Of particular note are Washington, Rhode Island, and Maine. In this year, in Washington, both chambers of the Washington legislature considered regulating the production, distribution, and sale of marijuana in Washington. In Rhode Island, House lawmakers reintroduced legislation to regulate the production, distribution, and personal use of marijuana for adults over the age of 21. And in Maine, a bill was introduced to completely remove all criminal penalties for the use or possession of marijuana for any purpose. In no instance have lawmakers or voters recriminalized marijuana after implementing more liberal decriminalization legislation. With respect to medical marijuana, as Senator Talion noted, 16 states in the District of Columbia, which combined are home to about 90 million Americans, or roughly 30% of the U.S. population. Those 16 states and D.C. currently provide legal protection under those state or jurisdictional laws for seriously ill patients whose doctors recommend the medical use of marijuana. And while the state programs differ from each other in significant ways, most have tightly controlled programs regulated by the state, typically the State Department of Health, overseeing the medical marijuana programs. Now, of course, you've all heard of the one state that really doesn't have state-regulated program, which is California, and that state is unique because California has left it solely to the local counties and cities to figure out controls for medical marijuana regulation, and in some places in California that hasn't worked out so well. With respect to the regulated distribution of marijuana, there are 7 medical marijuana jurisdictions: New Mexico, Rhode Island, Colorado,